Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. All right, one of the things you might, let me introduce Russ again. This is Russ Cook. Russ is a good friend. I've known Russ for over 15 years. And he's a board certified estate planning attorney. He's an excellent attorney, in fact, and he has helped a number of my clients over the years and still works with, we have a lot of mutual clients we work with. And I'm a big believer in a team approach. This is when I'm getting into tax planning, I'm bringing in, Dr. Friday, you see a lot of times, I'll bring her in as someone doesn't have an account, and I'll work with theirs if they do. Bring Russ in a lot of times on the estate planning piece, because this is one of those areas you need a really good attorney. You need someone who understands trust law. It's not something that they're going to pull a book off a shelf because they're actually more doing divorce or personal injury or whatever other areas of law they may practice. And not, it may be on really simple cases, that's okay. But if you really want the expertise of someone that just does estate planning, that's their specialty and understands all the different implications and ramifications of that planning, including the tax issues and all that, then Russ is your guy. And this is one of those areas, Russ, when we get into trust, and I really love trust. I think it's one of the best ways for most people, not every situation, of course, but for most people, I think they'll benefit from a trust. And then there's so many things, of course, we're talking about a revocable living trust, but then within that trust, you're, of course, creating additional trust. So I want to talk a little bit about, let's say that basic document, a revocable living trust, and some of the protections that you get here in Tennessee with that trust.
Yeah, the Tennessee is, as Hank put it, has some of the best trust laws. What we can do with trust planning, let's say that you want to protect the inheritance as it goes to your spouse or to your kids, but yet you do not want them to lose control over the assets. Well, instead of giving the assets to them outright, your revocable trust, or your will actually, can say upon your death that the assets go into a separate trust that is then held for the benefit of the surviving spouse or the children, and you can make the surviving spouse or the children the trustees of the trust. So in essence, their beneficiary, trustee, have access, complete control over the trust assets. But since the assets are held in trust, and this is happening after you pass with your assets, the Tennessee laws say that no third-party creditor, whether it's a ex-spouse or government claim or creditor claim, can go after those assets, even though the person that you're setting the trust up can go after and pull out as much or as little as they want as trustees. So it's a huge benefit. The other benefit that we have under Tennessee law is what's called a community property trust. This is advantageous for husband and wife. When a husband dies, normally he gets a step up in cost basis on the assets that he owns. That helps if the wife wants to sell those assets that are capital gain assets. However, most clients I find that are husband and wife own assets jointly. That means if the husband dies, his half gets a step up, but the wife's half doesn't because she's still alive. So if she sells that asset, she's going to pay capital gains on her half. Well, with a community property trust, which is basically a joint revocable trust, again, just like what we've been talking about up to this point, except it's for husband and wife. It's a joint revocable trust. It's created by husband and wife. They put their assets in it, just like Hank mentioned, and when the first spouse dies, not only is the decedent's share of the trust get a step up, but the survivor's share as well. So there's a huge capital gain benefit to all of this. And surrounding all of this process is knowing that when you do create a trust, you have to make sure you fund it. I know Hank hit that before, but really when I tell clients about revocable trust, it's not a one-step, sign it, done. It's a two-step process. You must not only sign the documents to create the trust, but you must effectively fund it as well.
This is one of those areas, understanding how this trust can work. So a revocable living trust means you can change it during your lifetime, of course. You're putting it in place during your lifetime as opposed to a testamentary trust, which, Russ could talk about as well with regard to a will. Sometimes people will create trust, but now you're going through that probate. So a lot of the benefits and advantages of a trust you don't really have, but it does give you some additional planning structure. So the revocable living trust is the one we typically go with, and with that, as Russ was just talking about the funding, but also the protection pieces of understanding how that works. So he just mentioned about a community property trust. Understanding when it comes to capital gains, this is an area sometimes we throw out our terminology and we may not, I want to make sure you're following with me on this one. So when Russ talks about a step up in basis, what he's talking about, of course, is the fact that let's say you bought a piece of real estate, and let's say you purchased that for $50,000, and now it's worth $250,000, okay? Now that's a $200,000 capital gain. So when you sell that property, okay, and we're saying in this situation, I'm thinking of a piece of land or a rental property as opposed to your residence. When you sell that, okay, you're going to have that pay tax on that $200,000 gain. And in that situation, it's about a 15% tax, so you're talking $30,000 in taxes on it. Now, let's say in the situation Russ was just talking about, husband-wife owning that property, you get a step up in basis on his half, so now we've covered part of it, all right? We've got half of it covered, but we're still going to have about $100,000 in gain. If the wife wants to sell it, let's say, she's still going to have a $15,000 tax. With the community property trust, and this is relatively new, Russ, right? This is how many years ago, maybe?
A few years ago,
just
2013, 2014, something like that.
If you're, and this is another thing to keep in mind. If you have, maybe you've done some planning and and have highly appreciated assets, but that planning goes back by 5 or more years, then this may not have even been available to you. So it's something you may want to do a review of your estate planning documents, and I'll give you an opportunity through my office to do that. So again, we're talking a community property trust. Now the whole asset gets stepped up, and you have zero tax if you wanted to sell that asset. Now that's a very, and this we've run into this so many times. I've got clients that've got multiple rental properties that they have fully depreciated, and this kind of advantage can be worth hundreds of thousands of dollars in tax savings. Imagine also stock portfolios with highly appreciated equities, or as we just mentioned, with real estate or equity mutual funds, those kind of things where you can have a lot of built-up capital gains in there because you've just held them and you haven't sold them, so your cost basis is relatively low to their value. This can be very advantageous, give you a lot more flexibility as far as monies. And what do we want to do ultimately, right? We want to, one, protect our family, but two, do you really want to have the IRS as your main beneficiary in your estate? Because the lack of planning, a lot of times that's exactly what you're doing. You're going to end up paying a lot more in tax than you might otherwise pay. And in fact, I'm going to throw out, Russ, this has been pretty basic, but you mentioned something earlier with regard to tax law, or the estate taxes. So why don't we talk a little bit about estate taxes? Inheritance tax we no longer have that in Tennessee, though of course it's always subject to come back as with everything, right? But the federal estate tax, we got a pretty high exemption, but that's not forever, ever, never, ever, amen.
No, it isn't. Right now, the state of the federal estate tax law is each person has an $11.4 million exemption. So between husband and wife, you combine those two, it's a $22.8 million exemption per couple. That exemption that we're talking about is part of a law that was enacted a few years ago that's going to sunset in 2026. Sunset means that that portion of the law is going to revert back to what it was before it was enacted. So in effect, what that means is that in 2026, the exemptions that we enjoy today are going to go away. The $11.4 million exemption per person is actually going to be cut in half to around $5 or $6 million per person, and the 22.8 obviously will then be cut in half to around $12 million.
Yep.
And with clients that are over the $12 million threshold, they're going to be having to make choices between now and 2026, because there are ways to make gifts and get the assets out of the estate and use that exemption, that higher exemption that we have now, before it goes away. But that involves some more sophisticated planning with trusts, irrevocable trusts, which are different from revocable trusts. but opportunities are there to help take advantage of that before that change occurs.
There you go. So you're talking about for high net worth people, for people that have, you're talking, a $20 million estate, for instance. This is a great way for you to be able to basically shelter an additional $10 million over what you may be able to do after, starting in 2026. And that sunset provision we talked about, there's some other implications that go with that. First, I got to take a break. So we're going to do that, and when we come back, we'll kind of wrap some things up for you and give you an opportunity, if you'd like to get some of this planning for yourself, how to do that. But first, a break. Join me here. We'll be right back on the Retirement Report.